Just when we thought all the commotion about George Zimmerman and Trayvon Martin was done, it appears that there's going to be a hearing in the United States Senate about stand your ground laws. One of the people who is going to testify at that hearing is the mother of Trayvon Martin. Another person who's going to testify is the mother of Jordan Davis. What the United States has is a lot of their law came from English common law. In English common law, before you could invoke self-defense, you had a duty to retreat. That would mean that if someone told you that if you didn't leave, they were going to beat you up, and you chose not to leave, and you got in a fight, then you cannot invoke self-defense. Then many states went through and continued on with English common law. These states are not stand your ground states. Then some states enacted stand your ground laws. Our political parties are groups of coalitions. They do not have any unifying principles. Stand your ground laws do play into the bloodlust of a certain component of the Republican Party. Those would have been the same people who cheered when, during the presidential debates, Rick Perry said how many people he signed the execution orders for. Then there are also mixed states. I happen to live in the state of Wisconsin, and it's a mixed state. In all states, you have to act reasonably when invoking self-defense. For example, if you have a gun and a 2-year-old comes at you with a hammer and says, "I'm going to kill you," then you probably are not acting reasonably to shoot the 2-year-old. If a 3-year-old comes at you with a hammer saying, "I'm going to kill you," you're probably not acting reasonably if you shoot a 3-year-old. And you can keep going up the ages, somewhere around 12 to 14 years old. Maybe, in fact, it would be reasonable to shoot the person. In the state of Wisconsin, it's a mixed state, so the jury may take into account your ability to retreat. You have no duty to, but it has to do with the reasonableness of your actions. Then clarifying reasonable actions with regards to self-defense. And in self-defense, you only get to use enough force to stop an unlawful interference with your life. For example, if somebody's sitting at the end of the bar near the entryway, someone enters, goes behind the person and knocks him flat on the floor, and then walks to the other end of the bar and orders a drink, the person who is knocked flat on the floor, assuming that the person evinces no further potential of doing them harm, does not get to go up and get off the floor and hit the person. Similarly, in the event you were doing concealed carry and someone came up to you on the street and pointed a gun into you and said, "Give me your wallet," you give them your wallet and they turn on their afterburners, you get out your gun and say, "Halt." If you shoot under those circumstances, it's not likely you'll be found guilty if you're charged with self-defense. self-defense. So the amount of force you can use in self-defense is only the amount necessary to prevent any unlawful interference with your life. The reason that George Zimmerman was found not guilty, and that is not guilty and not innocent, is that the state had to prove beyond a reasonable doubt that he was not in reasonable fear of receiving great bodily harm or death. Now you take the case of Michael Dunn and Jordan Davis. Michael Dunn has been sitting in jail for a little less than a year now, and even though he's presumed innocent, under the circumstances of his case, he will very likely be found guilty. I think he should be found guilty of second-degree murder because it will be hard to show that he intended to kill somebody, and he should have also been charged with 8 counts of reckless endangerment. He will likely spend the rest of his life in jail. So the clarity again is there are states where you have to retreat before you can invoke self-defense. There are states that are stand-your-ground states that indicate that you do not have to retreat before you can invoke self-defense. And there are mixed states where whether or not you retreated can be considered in terms of the reasonableness of all your actions.